Kia ora everybody, and welcome to Gibson Sheat's seminar on vaccination against COVID in the workplace. I'm Mike Gould, and this is Nikki Farrell, who works with me. And I'm going to talk initially about some of the legislation that's important, and then Nikki's going to carry on from there. So there are at least 6 pieces of legislation that are important, and that makes things a little confusing for everyone because even lawyers struggle to keep 6 pieces of legislation in their head at one time. But the first and the most important piece of legislation, I guess, is the Health and Safety at Work Act, which is the obvious starting point. And the primary duty of care that employers owe to employees is to ensure, as far as is reasonably practicable, the health and safety of workers who work for the employer while at work. And the Act gives you some guidance as to whether something's reasonably practicable and lists the relevant factors for making that assessment. And those factors are these. How likely is the hazard or risk to occur? What's the degree of harm that might result if it does happen? What are the known ways of eliminating the hazard? And are there available suitable ways to minimize it? And the final factor is how expensive is it to undertake one of those minimisation actions. So we suggest that in analysing those factors, many employers would rightly come to the view that requiring employees to be vaccinated against COVID-19 is clearly reasonably practicable. Obviously, there's quite a high likelihood of the disease reaching our towns. We know that if it does, serious harm can result. And we know that vaccination is available and cheap, and it does reduce and minimise the risk of health to our employees. But the responsibility in the Health and Safety at Work Act is not just that of the employer. The Act provides, and I'll quote, while at work, a worker must take reasonable care for his or her own health and safety, and that his or her own acts and omissions don't adversely affect the health and safety of others. So it's a two-way street. The employee also has these responsibilities. The Act also requires workers to comply with reasonable instructions given by the employer in complying with the Act, and to cooperate with reasonable policies or procedures relating to health and safety. The third act that might be important here is the Human Rights Act. Now, there's been a lot of discussion about this, and I think some of it's been a bit overstated. It's really more in relation to an employee who actually has COVID than a vaccination issue. So the Human Rights Act makes different treatment based on disability unlawful. Obviously, I can't treat an employee differently because he or she is, say, in a wheelchair. So arguably suffering from COVID amounts to a disability. So treating an employee with COVID differently on the face of it could be a breach of the Human Rights Act. However, there's an exception to that unlawfulness for disability, and that's stated in the Act as being where the environment in which the duties of the position are to be performed are such that the duties can only be performed with the risk of harm to that person, including the risk of infecting others with an illness, and it's not reasonable to take that risk. So treating an employee with COVID differently would not be in breach of the Human Rights Act. And the third piece of legislation I want to talk about is the Employment Relations Act. In particular, that Act requires employees and employers to comply with the duty of good faith. And helpfully, the section outlines what good faith means. And for our purposes, the most relevant section says the duty of good faith, quote, requires the parties to an employment relationship to be responsive and communicative. Nikki's now going to talk about some of the other pieces of legislation.
Thanks, Mike. The New Zealand Bill of Rights Act sets out the rights and fundamental freedoms of New Zealanders. The relevant section is section 11, which gives everyone the right to refuse to undergo any medical treatment. Medical treatment would include receiving a vaccination. However, this right is subject to justifiable limitations. The Privacy Act. Whenever an agency seeks or holds personal information, it must follow the rules and privacy principles in the Privacy Act. That applies to a business interviewing a prospective employee. This means that you just can't collect personal information, including vaccination status, for the sake of it. Collection of personal information must be lawful, fair, and not unreasonably intrusive. You must have a clear, lawful purpose for collecting the information, and you must tell the person the reason you need that information. The safest way to obtain that personal information is directly from the person themselves with their consent. There are certain roles that the government has declared require public health orders, that require compulsory vaccination. The public health order makes vaccinations compulsory for people in MIQ, most high-risk border roles, healthcare workers, teachers, and prison officers. However, yesterday's announcement expanded that. The Minister announced that vaccination will be mandatory for all workers and businesses where customers of the business need to show a COVID-19 vaccination certificate. That will cover hospitality and close contact businesses. Employers will be required to provide paid time off for workers to get vaccinated and to keep records about workers' vaccination status. Interestingly, the Minister made it clear that termination of employment would be an outcome in those businesses if an employee refuses to be vaccinated. A mandatory 4-week notice period for termination is being put into the legislation.
So they are the pieces of legislation that all have to come together, and we have to decide, am I in breach of the Health and Safety at Work Act if I don't do it, or do I need to do it? Am I in breach of someone's human rights? So it's a bit of a problem. It's being fixed, and as you can see, even as of yesterday, the rules were changing a little. But at the moment, if an employer considers there are specific roles, and these are roles not covered by the public health orders that Nikki's talked about, so it's not in the healthcare, teachers, prison officers. If you've got an industry outside that, but you still consider your workers might need to be vaccinated, then before you should start that process, you need to do a health and safety risk assessment. And that's an assessment of the role itself and the work being done rather than the individual performing that work. So how do you do that? Well, WorkSafe have put up some good suggestions for how you do a safety assessment. And that involves asking yourself 7 questions. And they are these. So in looking at this role, how many people does this employee carrying out that work come into contact with? And if the answer is very few, then it's a low risk. Obviously, if the answer is high, as many, then it's a higher risk. The second question is, how easy will it be to identify the people who the employee comes into contact with? If it's easy to identify them, such as it's only co-workers, then that's a lower risk. If it's difficult to identify because they come into contact with members of the public, then that's a higher risk. The third question in making that assessment is, how close is the employee in carrying out these tasks in proximity to other people? So if they're more than 2 meters apart in an outdoor space, then the risk will be lower. If they're in close physical contact in an indoor environment, the risk will be higher. The next point is, how long does the work require the employee to stay in that close proximity to other people? If it's just a brief contact, then lower risk. If it's a lengthy contact, then higher risk. Next question is, does the work involve regular interaction with people considered at higher risk of severe illness from COVID, such as people with underlying health conditions, etc.? Obviously, if there's little or none of that, it's a low risk. If there is contact with those people, it's a higher risk. The next question is, what's the risk of transmission and infection in our work environment compared with the risk for that person outside their work environment? And again, it's lower or higher depending on how you answer that question. And the final question that WorkSafe suggests is, will the work continue to involve regular interaction with unknown people if the region moves into a higher alert level? So those are the 7 or 8 questions that WorkSafe say you ask yourself, and then I guess in a way you mark out of a risk of 1 to 5 or 1 to 10 and say, well, on this spectrum, This person works closely with a whole lot of other people who we don't know, so the risk is up at the 10 level. This person works mostly on his or her own from home, so the risk is down at the 1 level. And doing that for all of those 7 or 8 questions will lead you to a conclusion as to whether or not this role needs vaccination for safety purposes. However, again, in yesterday's announcement, this requirement was tweaked even further. So the minister indicated that because of pressure from businesses and unions to make the process clear, the government's going to introduce a statutory risk assessment process for employers to follow when deciding whether vaccination should be the requirement of a particular role. He says the process will be, quotes, clear and simple. Well, let's hope. That new risk assessment process, though, would not override any risk assessments that have already been done using the guidelines from WorkSafe. Nikki.
Sorry. You may have noticed in the news that there have been a few cases involving staff being terminated for not being vaccinated. So the first one is about a recent employment authority decision about a customs worker. She was a border protection officer in a maritime port facility, and the government introduced the public health order requiring frontline workers to be vaccinated. She said she didn't want to be vaccinated and her employment was ultimately terminated. She brought a claim for unjustified dismissal and sought reinstatement. Customs conducted a health and safety risk assessment, which Mike talked about before, of the role and determined that yes, her role did require vaccination as she was at risk of coming into contact with the virus. Customs offered to explore alternative roles for her, but if that wasn't possible, then her employment would be terminated. Her application for interim reinstatement was dismissed by the authority, and her challenge of the decision in the High Court was also dismissed. The judge in the High Court said the court's task in this case was to balance the benefit of the vaccine and the risk of being unvaccinated against any discrimination in relation to those affected. Her unjustified dismissal claim is still to be heard. In another case, a claim was brought against the Civil Aviation Authority by 4 employees who were dismissed for refusing the vaccine when there was a public health order in place. Their application for reinstatement was dismissed, and their claim against the unjustified dismissal claim was heard last week, and we await the decision.
So in the context of those laws, what can an employer say and do regarding COVID-19 and vaccination of employees? Firstly, an employer might reasonably consider that we're in the midst of a dangerous epidemic, that information about employees' vaccination status is needed in order to assess the health and safety status of the workplace and its employees. Arguably, that means it would not be unlawful for an employer to ask employees about their vaccination status. But asking someone about their vaccination status is seeking personal information about them, and that information is protected by the Privacy Act. And you're only allowed to seek personal information if you do so for a lawful purpose. So, as I say, if the employer assesses that it needs to know the vaccination status and therefore ask its employees to tell them, then that, in my view, would be a lawful purpose and not a breach of the Privacy Act. But does the employee have to answer that question? Again, an employer might take the view that I need the answer to that because my employees are required to be, quotes, responsive and communicative. And you'll remember that's a requirement of the Employment Relations Act. So if an employer considers it was necessary to get that information, the law might even say that the employee was required to respond in order to be responsive and communicative. Now, on the contrary, you might get an employee, particularly in a workplace outside Auckland and Waikato, who says, well, look, that information is not yet required by you. There's no COVID in Invercargill. You're asking me about personal information is an overreach and it's unreasonable in the circumstances. I think you might hear that a bit. In my view, the employer's comeback would be to say that, look, all of the scientific medical information we're receiving is telling us that COVID's going to be in our town by Christmas. And it's perfectly reasonable for me as an employer, indeed, arguably it's required by the Health and Safety at Work Act, to take some action now to keep my work safe from the disease. And we're being told daily over and over again that vaccination is the key to protection against this disease. Now, if we do collect that personal information about our employees, we've got to protect it. We can't share it with other people unless there's an exception to one of the Privacy Act principles. And those exceptions generally require the employee's consent. There is one of the exceptions in the Privacy Act that disclosure of the information might be necessary to lessen a serious threat to public health or public safety. Now, it's unlikely that that would come into play. So when an employer does collect this vaccination status information about employees, it's got to be closely safeguarded. Okay.
So one question we've been asked is, can an employer amend existing staff employment agreements? The general rule is that an employment agreement can only be varied by agreement between the employer and the employee. So the answer is no. However, following proper consultation with employees, an employer is able to introduce policies. Arguably, a policy requiring employees to disclose their vaccination status is not a variation of the employment agreement. Many employment agreements contain a clause stating that the employee must comply with existing and future workplace policies. It might also be said to be in line with the Health and Safety at Work Act. You will recall that the Act requires employees to cooperate with any reasonable policy relating to health and safety. Can an employer ask prospective employees if they are vaccinated? Asking prospective employees about their vaccination status is seeking personal information. The prospective employer can do that only for a lawful purpose. So if you're going to ask about whether someone is vaccinated, you still need to have completed a risk assessment of the role to determine whether the person in that role needs to be vaccinated. You need the personal information of the vaccination status for a lawful purpose. What can be included in employment agreements of new employees? A clause can be included in an employment agreement for new employees that states that they are required to be vaccinated and that need to show proof of that vaccination.
Thanks, Nikki. I omitted to mention that we are taking questions and you'll be able to write them down somewhere on your screen. I don't know about that. On the Q&A box. Okay, thank you, Kyla. So what action can an employer lawfully take in regard to an employee who refuses to disclose his or her vaccination status or states that they're unwilling to get vaccinated? So the answer to that for employees covered by the public health orders is simple. If, following consultation, there's no alternative position with duties not covered by the order, employment will be terminated. And as Nikki said, that's already been upheld by the court in respect of some border workers. But yesterday, the Minister made it clear that non-vaccinated workers and roles requiring vaccination would require to be given a 4-week notice period to get vaccinated before employment could be terminated. So the more important question is for those who aren't covered by those orders. They're not teachers or health workers or so forth. And then we fall back on the Health and Safety at Work Act. And the employer's duty, as we've said, is to ensure, as far as is reasonably practicable, the health and safety of its workers. And the Act goes on to say that the employer must ensure, so far as is reasonably practicable, a work environment that is without risks to health and safety. So the obligation of an employer is to create a work environment that is without risk to health and safety. Now, given all of the scientific and medical literature and publications and the very strong push by central government for vaccination, we consider that it would not be unlawful for an employer to assess the risk of COVID-19 as being too high to ignore, and in order to provide that work environment without risks to health, to require employees who work in proximity to other people to have the vaccination. And if there are no alternative positions in the workplace that could be safely undertaken by the unvaccinated employee, for example, someone might be able to work without coming into contact with other workers, working from home, for example, then absent those options, then following full and proper consultation with that employee, termination of employment would be a justifiable action. And as I said, the Minister has said yesterday that there's going to be a statutory notice period for those people, and that's a 4-week period during which the employee is being given the opportunity to rethink and get vaccinated. So that's our opinion. But we do have to caveat that because it will depend on the outcome of a proper risk assessment and a reasonable conclusion to be drawn that vaccination is necessary for that particular role to keep that person and others in that workplace safe. And as I said at the start, the various statutes and law around these issues are sometimes in conflict. And obviously COVID-19 wasn't in existence at the time most of these laws were written. But our view is that there is a strong case to be made for an employer to be permitted to require employees to be vaccinated. Now, much of what we've said relies on PR statements from politicians and media statements about what the law is going to be. So it's when we see the actual legislation that employers will be able to be more certain about their rights and obligations. But that's where we think things sit for the present. So we're now happy to take any questions.
First question, what do we do if some roles should be vaccinated and others not, but they share communal spaces like smoker rooms?
So the risk assessment for the roles that need to be vaccinated has been done. They need to be vaccinated. The risk assessment for the other roles is that they don't need to be done. And so I take it the question is there's only the interaction in the smoker room. I think there probably should be reasonable steps taken to separate people from smoker time. It wouldn't necessarily be reasonable to conclude that, oh, because you go to smoker with someone who's not vaccinated, you've got your role also needs to be vaccinated. Nikki, what do you think?
Yeah, I think that'd be right.
Yeah.
Another question, if all other workers are vaccinated, is it okay to ask the non-vaccinated workers to follow suit, even though there is a low risk involved, given all the other staff have done this?
No, it wouldn't be. If you assess the workplace as low risk and therefore vaccination isn't required under the health and safety principles, isn't reasonably required, then you can't impose it just because everybody else has been vaccinated.
You could encourage it though.
You can certainly encourage it and should, yes.
How would these principles apply to contractors? Our workplace involves numerous independent contractors.
Yes, so the Health and Safety at Work Act puts a requirement not really on employers, it puts it on somebody called a PCBU, which is a person in control of a business or undertaking. And the obligation on the PCBU is to protect everybody who comes within that workplace, whether they're contractors or employees or visitors even. So the obligation is to keep that place safe for everybody who comes into it. So it's the same obligation. And of course, it would be easy enough for a business owner to require visitors to be vaccinated as well. The workplace is generally private property, and the private property owner is entitled to make the requirements for coming onto that property.
Okay. What happens for healthcare workers, for example, nurses that work remotely and therefore do not have any contact with patients or co-workers, i.e. they work from home?
Well, then it would depend on whether or not their duties were covered by the health order. And it says workers, the health order covers people in the health and disability sector, workers who work in close proximity to health practitioners. But the first group is called health practitioners. So if a nurse is a health practitioner, and arguably he or she is, then it's probable that the order covers him or her, and he or she would have to be vaccinated. But if it didn't, if I'm wrong there and a nurse isn't a health practitioner, then it would just require an assessment of the duties of his or her role to see whether or not it reasonably required vaccination or not. You can imagine people who work from home permanently would not be required to be vaccinated because they're not coming into contact with other people.
What about if people that are mandated to be vaccinated sit next to people that are not mandated or reach the threshold following the risk assessment?
So if the non-mandated worker is working in a role, then that role is assessed and the duties of that role assessed for its risk. Do I need someone in this role to be vaccinated because it's unsafe for them not to be? doesn't really make any difference that they're working alongside a vaccinated person. It's a question of establishing what the health and safety risk is for that person.
What are the liabilities on an employer or directors for a breach of private information concerning vaccination status, i.e. failure to keep private medical information safe?
Oh, well, Nikki might be able to answer that question.
I don't know the figure off the top of my head, but yeah, there is quite a hefty fine if you do breach any type of personal information. So you do need to keep that information as safe and secure as you can.
I think there's a couple of levels, aren't there? If the breach of privacy is at a low level, then the obligation to report it is not as strong. But if it's at a higher level, then there's an obligation to report, and then, as you say, some quite hefty fines.
Under WorkSafe 7 rules, is there contact with people with underlying health conditions? How would employers know if staff have underlying health problems to be able to keep them safe?
Interesting. They'll have to ask is the answer to that. So the consultation in the workplace for beginning this process is extremely important, both from a legal and from a relationship point of view. We need, in my view, to encourage our people to be vaccinated, but we don't need to be doing that in an intimidatory way. Of course, you need the information, and as we've said, it's lawful to seek that information. One of the questions might be an open question: is there anything else you want to tell us about our proposal to bring vaccination into the workplace as compulsory? So if you're not told, then you don't know. I guess the answer is that you should be seeking all relevant information about vaccination status or health status of employees in relation to COVID-19.
So if you are introducing a policy and have assessed half the workplace as high risk and the other as low risk, what takes precedence, i.e. if you can't separate out the high and low risk?
Well, you're assessing the duties of each role, and you probably don't want to do that worker by worker, but for example, you could have roles in a workplace where some of the people in, say, this office interface with clients who come in from time to time and some don't. Then you'd need to make different assessments for each of those roles and say, well, for the people who are client facing, the risk is higher, and therefore I'm going to require vaccination of those employees. But for the employees who don't client face, I'm not going to require vaccination. So it's not really a question of which takes priority. It's a question of assessing whether a particular role can only be safely conducted by someone who's vaccinated.
Who would be deemed appropriate to undertake the assessment? An internal person or an owner, a health and safety committee person, or an occupational health nurse?
I would say most employers are capable of undertaking that assessment themselves. They will need, of course, that guidance that the WorkSafe gives you, but it's really a question of, dare I say, common sense and saying, look, the risk of COVID is here, it's high. The risk of it coming into my workplace is high because of the answers to those 7 questions. Therefore, I'm going to require my people to be vaccinated. I guess if your risk assessment is going to be challenged, then the more expertise you have in arriving at that risk assessment, the easier it will be to defeat a challenge. But my view is that most employers would be capable of doing that themselves. But there are, of course, employment advocates and other advisors around who can help.
Can a workplace determine itself to be a vaccination certificate access site? So in turn require visitors, clients and workers to be vaccinated, like recently advised hospitality and hairdressers must do, for example?
Well, the answer to that is yes. And I think at last week's, or was it Monday's, I forget how many press conferences we've had, the Prime Minister announcing the traffic light one was clear to say, if you elect not to have a vaccination certificate regime, then you will not be supported in the same way as if you do. And Grant Robertson, the Minister of Finance, was quite brutal in saying if he doesn't want to be supporting with these surge payments, I think they're called, for businesses who are just ignoring the regime, so they will be penalised. So I think the vaccination certificates that will be voluntary for lots of organisations will soon be found not to be voluntary if you want to participate in business as fully as you could.
What if a role can work from home, but it's not ideal? For example, a lawyer.
Yes, that's a difficult question. Yes, and I have to say, I don't know the black and white answer to that. So we have lots of us over the last 18 months or so work from home, some quite comfortably and some not comfortably and some halfway in between. If the role can be essentially completed from home, even though it's a little bit inconvenient, my answer would be that that person should be entitled to work from home. It's a question of reasonability, isn't it? And at some point, the person working from home is missing out on stuff that's going on in the workplace and maybe isn't able to completely fulfill his or her role. So that's a difficult one that is going to be an assessment by the employer of whether I can have my people at home permanently or not.
Are you able to give guidance on designing an adequate risk assessment to use?
No, not in this webinar, we're not. But I think the real place to go is the WorkSafe website that gives you that series of questions to ask about your workplace risks. And as promised by Minister Wood, there'll be legislation within a few weeks, he says, that's going to give us a clear and simple process for doing a workplace assessment.
It's quite a specific one. What if everyone in the NGO works face-to-face with those in the community and one person had one injection in May and refused to have a further for religious reasons? This person shares an office with a fully vaccinated person.
Just repeat that for us, Kyla.
If everybody in an NGO works face-to-face with those in the community and one person had one injection in May and won't have a second, the person shares an office with a fully vaccinated person.
So if they are working with the community, I'm thinking the risk assessment of that role is going to end up being high, and that the employer would be entitled to require full vaccination as a condition of continued employment. The question is interesting because we may well face situations where there are roles that don't require vaccination, but vaccinated workers who work somehow around that person who's unvaccinated may be unhappy or feel unsafe about working with an unvaccinated person. But that doesn't detract from the employer's obligation to look at the duties of that particular person and say, no, there's no risk here, or there's a low risk here, or yes, there's a high risk.
What is your take on the medical exemption and its application? It seems very wide.
Look, I don't really know much about that medical exemption. I'm sorry, I haven't looked at that closely. So if that questioner would like to email us that, Mike.Gould, GibsonSheat.com, we'll look it up and give you an answer.
What is the responsibility of the employer to keep all employees safe within the actual work environment, i.e. colleagues working together aside from employee interactions with public or clients?
Yes, so that's the same obligation. As I said, the obligation in general terms is to maintain a work environment that is without risks to health and safety. And often there will be risks even in workplaces where there is no public-facing roles, simply because of the number of people working in the same area, perhaps sharing the same air as we do in lots of offices, not able to open windows and so forth. So that health and safety obligation of the employer is just the same whether there's public-facing people or not. The risk assessment may well be different though for a workplace where there is no public-facing and therefore less exposure to outsiders.
I think I'm following this next question. Due to a major client requiring details of our employees' vaccination status, We have prepared an employee vaccination disclosure form that is not client specific. What are the risks signing off on this? i.e., are we legally exposed?
Look, if you are asking your employees to give you this information because your major client has required it, then I don't think there's any harm in asking the question. In those circumstances, though, it may be that the employee does not want to answer. And if the employee doesn't answer what you do, that's the problem. You still, I guess, have to assess that employee's role and decide whether for yourself, not because your client requires it, but decide for yourself whether or not the role should be conducted or undertaken by a vaccinated person. And if you decide it shouldn't be, then you can't require that person to be vaccinated. And of course, you can't put them onto the work side of the client who requires the answer to that question. It's going to be a very difficult one from a privacy point of view, isn't it, Nikki? Because the client is saying, are all your people vaccinated? And the employer is saying, well, they may or may not be. I've done my risk assessment and I've found out from the ones I need to know whether they're vaccinated or not. But if the employees consent, of course, there isn't a problem. And asking them for a lawful reason, and the lawful reason being your client won't let you put unvaccinated people on site, sounds to me like a good reason.
Oh, that's the end of our questions. If anyone has any others, fire them through. Otherwise, email addresses are as listed and phone numbers if anybody wants to contact you.
Great. So thank you, everybody, for attending, and good luck with your risk assessments.
Thank you, everybody.
Thank you.